All right, we'll move on to the next question. The next question. Given the commitment of the medical profession to justice, that is equity and care, the provisions of aid and dying laws stipulate which patients are eligible for aid and dying, imply that some lives are not board members, and I know that some of the panelists have made statements in regard to this question already, but we'll allow them to address it again. Dr. Mitchell, would you like to start?
I should say no. First off, I mentioned this earlier, our value of youth, beauty, health, strength is what it is. It's I think, obvious in our culture, in our society. And the consequent devaluing of those who are not any of those things that results is very real, very common. We tend to institutionalize it. We think about our housing. Older and sick people, put them in a building somewhere else. Think of our transportation systems, how difficult it is for the frail, the ill to get around. In fact, one of the problems in my specialty, palliative care, is the conundrum. The people who need help the most from us have the most difficulty getting it. We resolve that by sending a hospice team to their home. But if you're not eligible or don't want hospice for whatever reason, then you're stuck with that conundrum. And so this value system in our society really does put a price on some lives and a very cheap price on others. And when we meet a person with existential suffering who doesn't feel that their life is of any value, and we agree to write a legal prescription, we're acknowledging the merit of their belief. I think sometimes it's worth disagreeing with that assertion. I hear the arguments counter to that, and they're valid as well. But it's really hard not to differentiate value of lives when we're engaging in writing the prescriptions.
Now I would expand briefly on my comments from before as well, that the very existence of this law is for a very privileged set of people. So the very law itself has indicated that there is value in the type of control freaks who write laws and write prescriptions compared to the types of folks from perhaps more vulnerable populations, people of color, people from more rural territories, people who would never ever think about accessing this law and who presently have access to potentially very poor or very limited alternative options in hospice or concurrent palliative care or anything else as well. So beyond, I think, the very real questions around does this law draw artificial lines in the sand around the people who can and cannot? I think the very existence of the law indicates that we're valuing a certain group of already very privileged people that much more.
Okay, the law is complicated for what reason? Because there are a lot of people who don't think they should ever be able to end their own life, and so they put lots and lots of restrictions on it. And so you can't blame the people who are advocates for this law for the fact that it's protecting all the vulnerable people is what's causing it to be so complicated. In answer to, or in response to, I don't have answers, but in response to the idea that this is a law that favors a certain group, that our healthcare system is imperfect, I'm very critical of our healthcare system. I've done it both poorly and in writing. But, you know, the aphorism, the enemy of the good is the perfect. If we're going to wait until we have a perfect healthcare system before we enact laws like this, then we'll never get anywhere. So I don't think that we should allow that to be an objection to this law.
Well, I'm going to put on my Latino hat for a minute here. The risk now that the law is here is that it will be used as a weapon against people of color, elderly people, poor people. One thing that happened in Oregon, it's been protected against explicitly in this bill, but one thing that happened in Oregon is that the state Medicaid organization, like say if you were, having had a cancer, you're requesting, some chemotherapy, well, they'd say, well, actually, you're not eligible for this particular chemotherapy. However, you are eligible for physician-assisted suicide. And so they would send letters like that to patients. Fortunately, that was horrendous enough that they kind of, they were called on it, they stopped doing that. But that's the explicit thing. It's protected against in this bill. But there's all kinds of indirect ways of saying the same thing. There's plenty of indirect ways of just kind of saying, well, it would be a little easier. It's kind of like redlining. If you're Latino or African American and you're wanting to look at houses, they say, oh no, there's these. Let's go look over here. And you're sort of directed to certain neighborhoods. You're directed to certain choices, and other choices are sort of walled off, or sort of you're dissuaded. And there's a real risk of that happening with this legislation. I mean, there's real risks of this happening in our healthcare system in general, which you alluded to. But now that we have this on the books, I think it's going to be important for us to think about ways of making sure that the transparency is there, that it's used correctly, that it's not used in some way to put subtle pressures on people to just be, be more convenient, don't be a burden, just kind of move along. So we need to think about that.
And so I think in other states that, so far at least, that hasn't been the case, so hopefully it will be the case here. But I'm looking at this in this other way, which is, and there's a precedent for it, right? So for example, wouldn't it be great if everybody with chronic illness could get palliative care, could get the kind of services that hospice provides, right? But there are certain